Richard and Stephen Mateer had a trial and special hearing in regards to sexual offences against two boys committed from 1989 to 1993. Unsurprisingly, most of the charges were found to be proven. On the 2nd of February this year, 2024, they had their first appearance at court for sentencing. This video will focus on last year's trial and special hearing, but in the next few days I plan to upload another video with details regarding their first sentence hearing. There are a number of media reports to cover, so at times I may skip ahead and not read parts that don't provide any new information. So I'll start with Nick Bealby's report on page 3 of the Newcastle Herald on February 11, 2023. Not fit for trial over child abuse charges. A man who pleaded not guilty to dozens of charges of indecent assault and child sexual assault, whose alleged offences were uncovered by detectives investigating the high-profile disappearances of girls who went missing at Lake Macquarie in the 1970s, has been ruled unfit to stand trial. Newcastle District Court heard on Friday that Stephen Mateer was found to have significant degenerative cognitive impairment, likely dementia. The court heard that when screened, Mr. Mateer's memory retention and speed was in the extremely low range, and he displayed a lack of awareness and insight. He was unable to describe recent meetings with his solicitor or details of accusations levelled against him, and did not have the capacity to make informed decisions about his defence. Stephen Mateer and his twin brother Richard Mateer were each charged with historical child sex counts when detectives from Strikeforce Arapaima, who were investigating the disappearances of several Hunter girls, including Robin Hickey and Amanda Robinson, were told of the alleged abuse of two boys in the 1980s and 1990s. Stephen Mateer last year pleaded not guilty to 45 counts, including multiple charges of sexual assault, aggravated indecent assault, and indecent assault against two boys. Richard Mateer has pleaded not guilty to 8 charges, including sexual assault and indecent assault in company in relation to one of the boys. They remain in custody and will face court again on February 20. Stephen will be subject to a 2-week special hearing, and Richard will face trial. Both judge alone matters. Okay, so the question we now have is, what is a special hearing? To answer that question, I'm going to refer to a booklet I found on the New South Wales Public Defender's website. It's called The Practitioner's Guide to Mental Health. So it defines a special hearing. It says a special hearing is similar to a trial, except that the accused cannot fully participate, and so does not have the opportunity to present a full defence. The Act acknowledges this at Section 54. So the Act is actually the Mental Health and Cognitive Impairment Forensic Provisions Act 2020. So it says in that section 54, a special hearing is a hearing for the purpose of ensuring, despite the unfitness of the person to be tried in accordance with the normal procedures, that the accused is acquitted unless it can be proved to the required criminal standard of proof, that on the limited evidence available, the accused committed the offence charged or any other offence available as an alternative to the offence charged. So, in other words, the basic purpose of a special hearing is that if they're unfit for trial, they can be found not guilty rather than having the charges hanging over their head and not tried. So in other words, if they were found not fit for trial and this didn't exist, they wouldn't be tried and the charges would just sit there. So it gives an opportunity for all the evidence to be heard, and if there's insufficient evidence, then they're found not guilty. Otherwise, there are other provisions if they are found that the offence did occur. So I'll now move on to the procedure, a bit of description there. The special hearing must be conducted as nearly as possible as if it were a criminal trial. The court may modify court processes to facilitate the effective participation by the accused in the special hearing. So basically, they try to have the trial in a way that, as far as possible, the accused can participate. The accused is taken to have pleaded not guilty, and the accused may raise any defence that could properly be raised if the special hearing was a trial and is entitled to give evidence. So they may not be cognitive to defend themselves sufficiently at a proper trial, but it is possible that they can give some defence at the special hearing if they are capable of doing so. Then a bit later it says the Crown may rely upon witness statements and other documents to present evidence. So that's probably going to be the main source of evidence that they normally present. So the next section, it goes on to talk about judge alone or jury. A special hearing is to be held before a judge alone unless an election for a jury has been made by the accused. The court being satisfied the accused received and understood advice about the election from a legal practitioner, the accused's legal practitioner, or the prosecutor. That's who may request a jury. So it can be accused as long as they've gotten sufficient legal advice, their legal practitioner, or the prosecutor. But otherwise, it will be a judge-only hearing. If a jury is put in place, then there are extra special explanations which must be given to the jury. So this includes letting them know that the fact that the accused is unfit for trial in accordance with normal procedures, the meaning of what being unfit for trial is, the purpose of a special hearing, the available verdicts, and the legal and practical consequences of those verdicts. But in this case, it appears that it is a judge-only trial. Now, the role of legal representatives at the special hearing: an accused must be legally represented unless the court allows otherwise. With a special hearing, it says the courts have acknowledged the difficulties that can arise in representing someone at a special hearing. And there's references to a few court cases. One says it's accepted the legal representatives would have more power to make decisions than they otherwise would in an ordinary trial, but they do not have exclusive power. So the accused can have input to those decisions. In another case, instructions at a special hearing can be problematic, and that the scheme requires the court to rely on the professionalism of the legal representative. And there was another case where it says there's difficulty of representing a client who has a mental illness, and that a legal representative is not always required to act on instructions. So in other words, in a special hearing, their legal representative does have much more responsibility, and they need to use that carefully. It then goes on to talk about the verdicts and sentencing at a special hearing, but I will discuss that more towards the end of this video. Anyway, on February 21, 2023, which was 10 days after the previous Newcastle Herald article, Nick Bealby reported on page 5 the following. Boy allegedly raped in van. A man on trial for alleged historical child sex abuse, some of which he is accused of perpetrating with his identical twin brother, repeatedly assaulted 2 teenage boys over several years, a court has heard. Stephen Mateer allegedly raped and sexually touched the boys he met through a Lake Macquarie pizza shop while they were aged between 12 and 15 years old. From 1989 to 1993, Crown Prosecutor Brendan Queenan said on Monday. Mr. Mateer, 70, was earlier this month deemed unfit to stand trial over 45 abuse counts due to impaired cognitive ability believed to be dementia. So is the subject of a special hearing in Newcastle District Court. The hearing is being run concurrently with the judge-alone trial of his twin, Richard Mateer, charged with 1 count of rape and 6 charges of assaulting and committing an act of indecency against one of the alleged victims, a 13-year-old in the company of his brother. Oh, sorry, that's a 13-year-old, and Richard Mateer committed that offence in the company of his brother. I'll skip the next paragraph. In the opening address, Mr. Queenan said it would be alleged the attack involving both Mateers took place in the back on a van. I think that should be of a van, not on a van, but anyway. He said the brothers allegedly touched the child on the genitals before telling him to remove his pants, then going on with an alleged ordeal that involved the boy being incited to manually stimulate each of the men before Richard Mattia raped the teenager. The acts Stephen Mattia is accused of committing on his own include allegedly inciting two teenagers to participate in sexual activity with each other while he watched and sexually stimulated himself. He also allegedly assaulted both boys on separate occasions while taking them for driving lessons, the court heard. The special hearing and trial continues today. So the next day he reports on page 12. So I'll continue. Twins abuse hearing delayed. The special hearing and trial of twins accused of historical child sex abuse have been unexpectedly delayed until May, with Newcastle District Court hearing on Tuesday. A key member of Defence Counsel had become aware she previously represented one of the alleged victims. So I assume that means a conflict of interest. The court heard on Tuesday morning of the conflict that had been discovered the previous afternoon following the first day of the judge alone trial and special hearing. So that put a little spanner in the works. So we now skip ahead to May 20, 2023, where on page 8 of the Newcastle Herald, Gabrielle Fowler reports, twins accused of teaming up in assault. Tendency evidence has been allowed against twin brothers on trial for alleged historical child sex abuse in the Belmont area in the late 1980s and early 1990s, some of which the pair are accused of perpetrating together. Stephen Mattia is accused of 45 counts of sexual assault, while his twin brother Richard Mattia is accused of 10 counts against the same two complainants. Justice Peter McGrath has accepted tendency evidence revealing that each of the two men were known to be sexually interested in young boys and had a tendency of acting on it. I don't have a legal background, but from this it appears tendency evidence is evidence to suggest that they have a tendency to commit such an offence, to be interested in such an offence, and to act on it. Stephen Mattia allegedly raped and sexually touched boys he met through a Lake Macquarie pizza shop while they were aged between 12 and 15 years old from 1989 to 1993, the court has heard. Stephen Mattia was earlier deemed unfit to stand trial due to impaired cognitive ability believed to be dementia. He has not entered pleas and is facing a special hearing under mental health legislation in Newcastle District Court, which started in February and resumed this week. The hearing has run concurrently with the judge-alone trial of Richard Mateer, charged with 1 count of rape and 6 charges of assaulting and committing an act of indecency against one of the alleged victims, a 13-year-old, in the company of his brother. He has pleaded not guilty. Victims of previous offending were similar ages to the complainants. The offending was similar to that alleged, and all of it occurred in the same area. So that would be the tendency evidence, I assume. Okay, I'll skip the next paragraph. It is alleged that the attack involving both Mateers took place in the back of a van. However, Richard Mateer has vehemently denied ever offending or engaging in any sexual activity in the company of his brother. I can't get around that word, vehemently. But anyway, you know what I mean. In the twins' defence, Justice McGrath is told that some of the complainant's evidence cast doubt across the credit of the other due to inaccuracies and inconsistency about who did what to who and who was present at the time. Identity is a critical issue, defence barrister Stephen Ryan said on behalf of his client Stephen Mateer. Another inconsistency was evidence from one of the complainants who said he tried to talk to the other one about the alleged assaults when they were 17 or 18 years old. One of them had already left the area by then, and the other one had no memory of the conversation, which was difficult to accept. 2 youths in their late teens trying to broach a very difficult subject, Mr. Ryan said. They did their best to recall certain things, but with the passage of time and the lives that they have led, it's the accuracy as to whether they have got the right person or people and whether the acts they allege to occur are made out, Mr. Ryan said. Well, memory is an unusual thing. It's not like a video recorder, so I think pretty much in any trial where you have multiple witnesses and that sort of thing, you are going to get discrepancies, so that's where it's up to the judge or jury to look at the differences and similarities and work out from that whether they can make a judgment that the offences did or did not occur. But anyway, I shall continue. There's just one last sentence. The matter is back before Justice McGrath on Friday, May 26. So we then go back to the reporter Nick Bealby again, who reports on page 22 of the Newcastle Herald on May 27, 2023. Twins abused children, judge. A man who was unfit to stand trial over dozens of historical sex abuse charges, some of the acts performed alongside his twin brother, has been found to have committed most of the crimes of which he was accused. Stephen and Richard Mateer faced a concurrent special hearing and judge-alone trial, respectively, in Newcastle District Court. Stephen Mateer was deemed unfit to face a trial on the 45 counts levelled against him due to dementia. Judge Peter McGrath on Friday afternoon handed down his verdicts, saying he was satisfied beyond reasonable doubt that Stephen Mateer committed all but 3 of the offences. Richard Mateer was found guilty of all 8 counts he faced, related to the abuse of one boy. The court heard that Stephen Mateer preyed on 2 boys while they were aged between 12 and 14 in the Lake Macquarie area from the late 1980s to the early 1990s. In one attack in the back of a van, the brothers touched the genitals of one boy before inciting him to manually stimulate them. Richard Mateer then raped the child. Judge McGrath found that Stephen Mateer sexually assaulted this boy and another while taking them for driving lessons. The Mateer twins remain in custody. The case will be mentioned in Newcastle District Court again on July 13, as further health reports are obtained before sentencing proceedings take place. Okay, so I didn't come across any media reports relating to the July 13 hearing in 2023 last year. I assume that was probably because it was just presenting the medical reports and possibly setting a date for sentencing. So there was probably not enough information there for the media to take interest. But anyway, the Sunday Telegraph on May 28, 2023, so the day after the Newcastle Herald report, had an article on page 25 by Dan Proudman. Evil twins abused more boys. Identical twin serial pedophiles, Richard and Stephen Mateer, have been found guilty of abusing more boys, dating back more than 30 years, including one they assaulted together in the back of a van before giving him a soft drink. The 70-year-olds watched via audio link from different sections of Long Bay Jail on Friday, as Newcastle District Court Judge Peter McGrath, SC, explained his verdicts involving the horrific abuse of boys in the Lake Macquarie area between 1989 and 1993. The Mateers, both of whom have already served significant jail terms for abusing other boys dating back to the 1980s, were again arrested in 2021. The identical twins had faced simultaneous judge-only hearings. Stephen Mateer a special hearing on 45 offences involving 13 separate incidents involving 2 boys he was found unfit to stand trial due to dementia, and Richard Mateer on trial for 8 counts relating to one boy. Judge McGrath said he was satisfied beyond reasonable doubt that Stephen had committed 42 sex offences, including 8 lesser offences, after finding him not guilty of 11 charges. So he had 45 charges originally. 11 of them were dropped, though 8 of those were aggravated and the new charges were considered lesser than aggravated but similar charges. So in other words, had 45, 11 dropped, 8 added, but they were just lesser offences for the 8 of the ones that were dropped. And Richard, guilty of 7 counts of sexual assault, assault with an act of indecency in company, and 1 count of sexual intercourse with a person aged between 10 and 16. Both will face sentencing hearings later this year. As far as I can tell, there were no sentencing hearings later that year. The first of the sentencing hearings was the 2nd of February, which I'll talk about in the next video. Okay, so that article I just read, Dan Proudman actually had an extended version of that article online 2 days before, and it gave additional information which I shall read now. The trial heard evidence that Stephen Mattia used his pizza shop to groom the boys, giving them free food and drinks before abusing them both with his brother and on his own. They talked one boy into the back of a van before abusing him and then buying him a soft drink after fondling him as he sat between them in the front seat. Judge McGrath also found Stephen incited 2 boys to both have sex with each other and perform sex acts on each other as Mattia watched and became involved. Both Mattias had argued the boys had incorrectly identified them as their abusers and there were inconsistencies in their evidence. But Judge McGrath said he accepted the evidence of both victims. He also mentioned the tendency evidence admitted during the trial, which showed both Mattias had a sexual interest in boys aged between 10 and 16 and had a tendency to act on that sexual interest. Stephen Mattia has previously been jailed for 10 years for sexually assaulting 6 boys, while Richard Mattia was given a 12-year maximum term for sexually assaulting 5 boys. So not very nice brothers. Okay, so now they have both been found guilty. We expect Richard will undergo the normal sentencing process, but what will happen after the special hearing for Stephen? So I'll go back to that booklet from the Public Defender's website. Okay, we have verdicts in a special hearing. There are 4 possible verdicts following a special hearing. Not guilty of the offence charged. That's not the case here. Special verdict of act proven but not criminally responsible because of mental health impairment or cognitive impairment. I assume that would apply if they were impaired at the time they committed the offence. I don't have a legal background, not totally certain of that, but I think that would be the case. The third one is on the limited evidence available, the defendant committed the offence charged. So I think that applies with most of the charges for Stephen Mattia. And the fourth one is on the limited evidence available, the defendant committed an offence available as an alternative to the offence charged. So that would be the 8 new charges that he was found guilty of, which replaced 8 of the 11 that were dropped. So those last 2 points apply. So basically, if they're not guilty, they're essentially released. They're not considered a forensic patient. If one of the other verdicts is returned, so we've got the 2 last ones, the court may, of its own motion, request a report by a forensic psychiatrist who's not currently treating the accused. And as to the accused's condition, so some details on that, and whether their release is likely to seriously endanger their own safety or that of any member of the public. The court may consider the report in determining what orders to make about the accused. Yes, so in other words, that could be what was happening at the July hearing. The judge has ordered a report and he's going to look at that in July and take it from there. Well, that's July last year, 2023. Okay, there's a section on the offence committed on limited evidence available. So that's what we're looking at. If at a special hearing the court finds that on the limited evidence before it the accused committed the offence charged or an alternative offence, a qualified finding of guilt, the court must decide on the appropriate penalty. If the court would have imposed a sentence of imprisonment, it must nominate a limiting term that is the best estimate of the sentence the court would have imposed. Refer the person to the tribunal, and the tribunal is actually the Mental Health Review Tribunal, may make an interim order with respect to detention in a mental health facility, correctional centre, detention centre, or other place pending review by the tribunal. I'll read on. In determining the penalty to be imposed, the court must take into account that because of the accused's mental health or cognitive impairment, or both, they may not be able to demonstrate mitigating factors for sentence or make a guilty plea for the purpose of obtaining a sentencing discount. So, in other words, I assume the judge has got to make a determination of how competent they are to plea mitigating circumstances and whether there would be any, and may reduce the sentence in accordance to that possibility. Yes, so it says that they may apply a discount of a kind representing part or all of the sentencing discounts that apply to a sentence because of those factors or a guilty plea, and must take into account periods of the accused's custody or detention before, during and after the special hearing relating to the offence. I think that's normal with a trial as well. And then it says at the end, or towards the end, the court must refer the accused to the tribunal if it nominates a limiting term and must notify the tribunal of orders it makes under the section. The tribunal takes over the treatment and supervision of the person, including the disposition of the person. So, in other words, from what I've read elsewhere, the tribunal takes responsibility for the detention of the person, where and how they will serve their detention and under what conditions. And at the end of the period of their detention, it is even possible that their detention could be extended, but that is subject to an order from the Supreme Court. Okay, so the trial of Richard and Stephen Mateer was complicated by Stephen starting to suffer what appears to be dementia. So it was considered he couldn't properly defend himself and as such could not be tried, but under provisions of an act which I mentioned previously, and I'll write it down here because I can't remember, he had a special trial, which is pretty much a special hearing, I should say, which is pretty much run along the same lines as a trial. And it was run in conjunction with the trial of his brother Richard. And probably not unexpectedly, they were pretty much found guilty of most of the offences that they were charged with. And we are waiting for the sentencing to occur. Actually, there was a first hearing on the 2nd of February this year, 2024, which, as I've already said, I'll try and upload another video on that in the next few days. Well, that was a rather long video. I promise my next video will be much shorter and make up for that. But anyway, if you'd like to watch more of my videos, including the one I'll be uploading in the next few days, then please subscribe and click on the bell to be notified when I upload the new videos. I'm David A. Elliott. Have a good one and see you around like a risol.